Morning.
Morning.
Thank you for joining. Thank you for joining today's session. And as usual, please may I ask that we mute our mics and only unmute if you have a question or you want to say something. Can we please mute our mics and only unmute if you have a question or you want to say something? Today we are going to have a discussion about maintenance of a spouse after divorce. As we all know that one of the invariable consequences of getting married is that spouses who are in a valid, legally recognized civil marriage owe each other a duty of support. Basically, that means that either the wife or the husband, they have a legal obligation to financially support each other. When the marriage terminates during the process of divorce, the spousal maintenance comes to an end. This is in terms of common law. Which states that the duty to support between spouses come to an end when the marriage is terminated. Although common law states that the duty comes to an end when the marriage terminates, there are exceptions which are regulated by Section 7, subsection 1 of the Divorce Act and Section 7, subsection 2 of the Divorce Act. Now, my question to you is, let's start with Section 7, subsection 1. What do you understand by it? Anyone, when we say that during the process of divorce, a spouse can rely on Section 7, subsection 1 of the Divorce Act. Can any one of you just take us through basically what does that section talk about? Anyone, students? I'm waiting. Okay, Ethel?
Good morning, ma'am.
Morning.
My understanding about section 7, subsection 1 of the Divorce Act is about the agreement that the spouses have agreed on, that it binds them even during a divorce. Whatever they have agreed about the maintenance on the agreement, it still binds them, even if maybe a spouse with section 7 subsection 2, it says if a spouse remarry, then the spousal maintenance comes to a stop. But with the subsection, with section 1 subsection section 7 subsection 1, sorry, it doesn't apply, because even if the other spouse remarry, like the spouse who receives the spousal support remarry, but the agreement said maybe, for example, you have to support the spouse for 24 months, but the spouse marries maybe a year or 6 months later after the divorce is finalized, you still have the responsibility to pay that maintenance as per agreement. Section 1, section 7, subsection 1, it talks about the agreement that the two spouses made with regard to the spousal support after the divorce.
Okay, thank you, Ethel. You are correct. Section 7, subsection 1 of the Divorce Act regulates spousal maintenance post-divorce when spouses enter into a contractual obligation to pay maintenance. As we have discussed before, that spouses who are undergoing a divorce have an option of entering into a settlement agreement. So in the settlement agreement, they can include a clause where one spouse states that they will continue providing spousal maintenance to the other spouse, and then that clause it will usually contain the terms of how much the maintenance is going to be paid, when it's going to start, and when it's going to finish, or when the maintenance is going to come to an end. If the section is silent on when the maintenance is going to come to an end, the court normally promote, or they normally promote a continuation of it, meaning that even if, let's say, the recipient of the spousal maintenance remarries or goes and lives in a cohabitation relationship with another partner where they are financially supported, the spousal maintenance will continue up until either their death or the death of the debtor. In other words, the person who pays the maintenance. So section 7 subsection 1 is about a maintenance which the parties, they themselves have agreed on paying, and they agree on it in the settlement agreement. Now, section 7 subsection 2, as Ethel stated, this one is regulated by the law. The courts are given discretion. Okay, before I continue, let's hear what Lituma wants to say. Lituma?
Yes, ma'am. I just want to know this section section 7 subsection 1.
Yes.
Now, if in case now, I'm just thinking if the other partner get marries and in community of property, won't it have now some complications in a sense that now the other partner now has got now also a share in your asset? So wouldn't that cause some sort of complications?
Okay, it can cause complications, but remember, when you enter into a COP marriage, a community of property marriage, the rules are COP, you get to share and get to be liable for what you had before the marriage and during the marriage. So the assumption is you, as the new spouse in that marriage, you knew what you were getting yourself in. So if, for example, the husband is still paying maintenance to the ex-spouse, that debt now will fall into the joint estate. So for the recipient, their rights will not be affected, but you, as a new spouse in the COP marriage, that is going to affect you, because it is part and parcel of the consequences that comes with being married in community of property. Do you understand? Because it's like any other debt. Remember, if you enter into a COP marriage and then you have a student debt, your spouse will automatically be 50% liable for that student debt. So in this case, the only difference is now it is a debt, or it is a maintenance claim where you have to pay your former spouse. But unfortunately, you being a party to a COP marriage, it's just part of what comes with that marriage regime. Okay, I hope you're able to understand, Lituma. Okay, as we continue.
Yes, ma'am.
Okay, thank you, Lituma. Section 7, subsection 2. Here is when the parties have not entered into an agreement, but their spouse who needs the maintenance, and I'm stressing the word need, because in order to get spousal maintenance, you must be in financial need. So the spouse who needs the spousal maintenance must bring an application to court, and this application must be brought during the process of divorce. Once the divorce has been finalized, you cannot make an application for spousal maintenance. So the spouse must bring the application for spousal maintenance during the process of divorce, and the courts are given the discretion to either grant an order of maintenance or to reject an application for maintenance. there are grounds that the court look at in order to determine whether they should grant an order for maintenance or refuse an order for maintenance. Now, my question to you students is, do you know those grounds? What are the grounds that the court look at in order to determine whether to give an order for maintenance or to reject an order for maintenance? Can we talk about those grounds? Anyone? Students? I'm waiting. Just take a guess, then we'll just have a conversation. You can raise your hand and then you can just take a guess. Batini? Batini, let's start with you. Batini?
Yes.
Yes, Batini, you can continue.
Can you hear?
Yes, we can hear you.
Yes, I believe one of the grounds, ma'am, it's when where the court can refuse to grant the spousal maintenance is when one of the spouses has got enough, or let's say is working and can live with her own or his own without the other one.
Okay, you are correct in that for a spouse to firstly request spousal maintenance, there must be in financial need. So if you are earning and if you are working and earning a decent salary, you are not in financial need. So automatically that one disqualifies you from even making. You can make an application for spousal maintenance, but the fact that you are not in financial need, the court will not grant an order. Now let's talk about the factors that the court must take into account in order to give an order for spousal maintenance. Zinhle Nanosi?
Yes, ma'am.
Yes, Zinhle?
Yes, I think another factor the court has to consider is whether if the person who claims for this maintenance is not the one who contributed to the breakdown of the marriage. Hello.
Okay. Okay, no, we are hearing you. We are hearing you. Okay, when you are saying, okay, let me just give an example. So if I am married and I was a housewife, and I'm married to a businessman who is really at home, and due to loneliness, I found myself a boyfriend, and he finds out and he files for divorce. Are you saying because I had an affair and I was financially dependent on him, I should be disqualified from claiming spousal maintenance?
Yes, this is what I think, ma'am.
Okay. Okay, thank you for that. Let's hear others before to continue. Zulinde, you can unmute. You can mute yourself. Musibati. Okay, Musibati. Yes, you can continue.
Yes, I think the court should also look at the duration of the marriage and also the spouse standard of living during the marriage.
Okay, you are correct about that, but let me just say something regarding the standard of living. The courts these days, since we follow what we call the clean break principle, they follow the notion, or they believe the notion that once the marriage has terminated, a former spouse cannot expect to actually live the same standard that they were living while they were still married. So although looking at the standard of living of the parties while they were still married, it is one of the grounds that the court will look at. But if, let's say, the spouse is successful in obtaining an order that they'll be granted a maintenance, spousal maintenance post-divorce, the court will not order the same amount. Let's say during the marriage, your husband used to give you 20,000 spousal allowance. So after the divorce, the court can say, okay, yes, you're going to be granted a certain amount, but they will not necessarily still give an order for 20,000. There was in the news just recently where a high court, there was a high court order, I just forgot which court was it, where the former spouse brought an application for spousal maintenance, and her argument was her monthly expenses are about 100 and something thousand rand, because she's still living with major children, but they are major dependent children. She was successfully in the spousal maintenance application, but the court only granted her 35,000 rand and not the 100,000 that she requested. So my point here is just to show you that although the standard of living while she was married, she used to get, let's say, 100,000 from the husband in order to maintain her standard of living and that of the children. Now that they are undergoing a divorce, the court has acknowledged that yes, you do need some money in order for you to live and to be able to afford the basic needs, but the amount has been drastically reduced because she cannot expect to live the same standard of living post-divorce. I hope you understand, but you are correct in your factors. Let's hear others. Let's hear what Rai has to say. Rai?
Yes, ma'am. The court also considers the spouse's age.
Yes, you are correct. And on the age, why this one is important? Remember?
Yes, ma'am.
Okay, you can say before I talk. Did you want to say something?
I think yes. I think it is important in a sense where if you are getting a divorce and you are still young, you are still at an employable age.
Yes, so you are.
You are still at an employable age, and if you are still employable, the court cannot grant you that maintenance because you can still go back into the market and get a job.
Okay, you are correct. The age is very important because there is a difference between a former spouse who is 30 years, who is 40 years, and a former spouse who is 50, 60, 70. And also with age, they also look at, okay, what are the chances of you being re-employed? A spouse who is a spouse undergoing a divorce who is 60 years, let's say from 55 years, 60 years, who has never worked, who has been either maybe just this part-time jobs, but most of throughout the marriage, they were the homemaker, they were the housewife. Chances of them being granted spousal maintenance until death or remarriage is extremely high versus a younger former spouse who is still versus a spouse who is still very young in their 30s, 40s, early 50s, where chances of them being reintroduced into the market or being given awarded a certain portion of money of maintenance for a certain period of time, what we call rehabilitation maintenance. Those ones, they tend to not be given permanent maintenance, but rehabilitation, a rehabilitative maintenance, which is maintenance that you are granted for a specific period of time, and that during that time you are expected to get yourself back on the feet, so that you end up being in the position where you become self-supporting. You no longer rely on your spouse. Okay, let's hear what Busisiwe has to say. Busisiwe?
Hi, ma'am. The other factor that is taken into consideration by the courts is childcare responsibilities.
Yes, you are correct. Although we've got spousal maintenance, and we also have child maintenance. The responsibility as the primary caregiver are not just with relate to finances, but remember, when you look after children, especially by the children who are still very young, there's a lot that goes into taking care of the child or of the children. So the courts do take that into account, but they also take into account a spouse who is still living with major children who are financially who are still financially dependent. Although adult children who are still financially dependent have the right to go and sue for maintenance in their own rights. In other words, without their parents bringing a maintenance claim on their behalf. The court does take into account that the spousal maintenance is needed because some of the monies will be used to benefit the major children of the ex-spouse. So you are correct. Tando?
Hi, how are you, ma'am?
Hello, Tando.
Yeah, can I please ask something, ma'am? Uguti, when the partners are in a process of the spouses are in a process of divorce, and the one that the maintenance is demanded from loses their job, what happens?
Okay, the person who asks for maintenance must be in financial need, and the spouse from whom the maintenance is requested for must be in a position to be able to afford it. So if they lose their jobs, now they are able to prove that they will not be in a financial position to afford the maintenance. So as a result, the requirement that other spouse must be able to support, to afford the maintenance will now fall away, and then meaning that no spousal maintenance will be awarded.
Okay, thank you, ma'am.
Yeah, but can I also state this also will depend on the marriage contract that the parties have entered into. Let's say, for example, the spouses are married in community of property. When you are married in community of property, you can claim 50% of the pension fund, and you can also claim your share of the let's say the spouse is being retrenched, your 50% share of the retrenchment package. But if you are married out of community of property with the accrual, they will do an accrual calculation, and then if that spouse who has lost their job, they are going to get pension, they're going to get retrenchment packages, and then their estate is much higher than the spouse. Let's say the estate is not that much higher. The two spouses have the same. In other words, the estate has not grown that much, but that other spouse is going to receive lump sums from the pension and retrenchment packages. The court can order that a lump sum amount of spousal maintenance be paid from the monies that that spouse is going to get. The same position will apply for a spouse who is married with complete separation of property. If they can prove that their spouse, although they have lost their job, they are going to receive quite a large amount of lump sums. The court can order spousal maintenance and order that a lump sum be paid from the packages that they are going to receive. The only time the court will not grant a spousal maintenance is when that spouse who has lost their job is not going to get much from their packages. Let's say they didn't even have they didn't have pension, or they had pension but it's not going to pay much money, and then even their retrenchment package, then it means they don't have the means to be able to afford the spousal maintenance.
So ma'am, there's a minimum amount for the maintenance.
There is no minimum amount. Like, for example, a spouse, let's say, who's about to get 200,000, and from that 200,000, they need to kickstart their life again. So if the court says, okay, we are going to order a maintenance order of 50,000 or 100,000, it's going to negatively impact on the other spouse because they themselves they actually need money to actually survive. Remember, the common law rule is once the marriage comes to an end, once it is terminated, spousal maintenance comes to an end. So that other spouse, although they're going to receive money, they cannot be punished and their lives cannot be the court cannot give an order that will make that will impact negatively on the ex-spouse. But there is a difference with a former spouse who's going to receive, let's say, 1 million or 2 million. The court can grant an order, can maybe say, okay, pay your former spouse a lump sum amount of 100,000 or of 200,000, as long as whatever has been ordered, it is not going to negatively impact the other spouse, because at the end of the day, the duty of support is terminated once the marriage has come to an end. So matters like this, the court looked at them on a case-by-case basis. There is no standard answer to this. Okay. Do you understand?
Yes, I do, ma'am, but I have one last question. So when we
Okay.
go back to the pension amount, so it doesn't necessarily become a maintenance because you pay that amount when you get your pension. So it becomes a once-off amount.
Yeah, but remember, it becomes maintenance if the court orders, let's say the court orders your husband to give you a lump sum spousal maintenance of 200,000, and you are going to the husband is going to use his pension to make payments. Is going to use pension to make payment. So the 200,000 that they will be paying, they will not be paying it as a share for the pension, but it is an amount that they will have, because once they've left or once the job has been terminated and they are no longer a member of the pension fund, once the money it is now in their bank account, that is where the money is going to be paid. Or an agreement maybe can be entered between the two parties whereby they say you're going to pay me this lump sum, but this lump sum then we can enter into a settlement agreement whereby we put in a clause, and then we say your pension administrators can pay me a certain percentage, let's say 20%, which 20% is going to amount to that 200,000. So it is important for me, for you students to understand that although the money can come from the pension, the reason why, let's say, the husband is using the pension money because that is where he can afford the lump sum from. But if you are married income of property and you are going to get 50% of the pension, the court cannot order that another lump sum be paid if the husband again is also now going to be unemployed. Here we are talking about a situation or a position whereby both spouses, let's assume both spouses are now unemployed, but one spouse is going to receive a large amount of lump sum and they are going to receive it from their pension. Do you understand?
Yes.
Okay. Thank you. Let's hear what Rai has to say. Rai? Hello, Rai?
Yes, ma'am. My question is in regard with where we are married in a COP marriage, community of property, and then we share 50%. He get his, and then after, can I still claim the maintenance after divorce at the spouse because I was not working, but I still got my 50%?
Okay, no. The key word is, are you in financial need? So if you receive, let's say, 500,000 or 1 million, you are not necessarily in financial need. So in order to answer that, you can maybe the court maybe over and above the 50% that you're going to get from pension. It will firstly depend on the amount that you're going to get, but the court can order rehabilitative maintenance, which is just maintenance for a certain amount of time, let's say 24 months or 48 months, which is like is either 12 months, 24 months, 12, 24 months, or 48. They normally don't go exceed the 48 month period, and that is just also to enable you just to get back on your feet. Understand? So if you got 50% of the pension, the question now is going to be how much did you get, and with that amount can we still say you are in financial need? So if you can prove that the amount that I received from the pension is not enough just to enable me to get back on my feet, like 100,000, 200,000 is not really enough to get back on your feet. If getting back on your feet will require you to find alternative accommodation, maybe go back to school, or just do a certain course that will help you to at least get a job. Understand? So the court will order rehabilitative maintenance, but depending on your age again.
Sorry, ma'am, can I please interrupt?
Okay.
There are students on Telegram, they can't join via the link that is provided. So may you please send the link in the chat box if you can, then I can copy and paste the link and send them the link so they can be able to join the class, please.
Okay, it's fine. I'll just send it now.
Thank you.
Okay. I hope I was able to clarify how it's possible to get still pension, but also for the court to give an order for maintenance. Just remember that the key word is need. Is the spouse who needs maintenance in financial need. If they are not in financial need, the court will not grant an order for maintenance. Okay, let's hear what Bonolo has to say. Bonolo?
Thanks, ma'am. My question is around the duration of the marriage. Till when does the court take into account spousal maintenance support with regards to the duration of the marriage?
Okay, each case is judged on its own merits, but marriage which usually lasts within, let's say, for a year, 2 years, the courts are usually reluctant to order spousal maintenance unless if like they will look at the circumstances that led to the breakdown of a marriage. Let's say the spouses entered into a marriage which is less than 2 years, and then in that 2 years the wife was unemployed, being a housewife, and the marriage was extremely abusive, and the husband did not allow the wife to work. The court can order maintenance, but they will order rehabilitative maintenance. It is unlikely that they will order permanent maintenance. So the longer the parties have been married, the good chance that the court may order spousal maintenance if other grounds have been complied with. But the shorter the marriage, the less likely that the court will grant an order for spousal maintenance. To understand.
Yeah.
See, so again, each case will depend on its own merit.
Okay, thanks.
Okay. Thank you. Musibachi, student, can I ask that once you've asked a question and you don't want to ask something else, please remove your hands so that I can know those whose hands are still up. I can see those whose hands are still up and those who still wants to ask questions. Okay, let's start with Sizo. Sizo? Sizo?
Hi, hello.
Yes, Sizo.
Yes, I would like to be a little bit off topic. I would like to know how to reference because I'm doing one of my assignments. I just want to know how to paraphrase and so on and so forth. That's it.
Okay, Sizo, can you send a private email on that so that that is something that is discussed privately?
No problem.
Yeah. Okay,
Thank
thank
you.
you.
Can she also
Okay.
refer to tutorial 301?
Okay, Sizo, I hope you had that tutorial 301.
Yeah, 301. For all LLB students, they will guide you.
Okay,
Okay,
thank you, Sizo. Nomsa?
Thank you so much.
Okay, Nomsa? Nomsa?
Hi, ma'am. How are you?
Fine, and you?
I'm good, thanks. I have a question. If it
Yes,
happened that I filed for divorce, then I got the maintenance, the spousal maintenance. Then my husband got retrenched. Then he get another job. Will I be able to apply again for a spousal maintenance if I'm in need of finance?
Okay, it's going to depend. It's going to depend on what the court order says. Let's say the court order disposal maintenance was granted in terms of section 7 subsection 1, where the parties entered into a settlement agreement, and into that one of the terms is should the spouse who's supposed to pay maintenance, if they leave, if they are no longer working, the maintenance will come to an end. If they receive, if they get a job again, what will have to be looked at is what does the agreement say in terms of them getting a job again. If it says nothing, then it will depend on the interpretation of the court, whether the court will interpret it to mean that it will continue, or by merely losing the job the very first time, then that automatically means the maintenance will come to an end. But if the clause says the maintenance is supposed to be paid, let me say, for 5 years, if they lose their job, the maintenance can be suspended, and then when they find their job again, then the maintenance has to continue. But then you, as the spouse who was receiving the maintenance, you can also claim back for the period that he was not paying, because in terms of the agreement, the maintenance is supposed to be paid per month for a period of 5 years. So everything will depend on what the court orders.
Oh, okay. So the other question is it possible for a spouse to claim for maintenance from his or her spouse for the time that has been wasted during their marriage?
Okay, what do you mean for the time that has been wasted?
If someone said, I will claim maintenance against you for my time that you have wasted regarding their marriage in terms of divorce, after divorce.
Okay, firstly, you cannot claim spousal maintenance after divorce. Secondly, what I'm not understanding with your question is the word for the time that you have wasted. Remember, when you get married, you can't necessarily say you wasted my time. Either a marriage succeeds or it doesn't. So in order for you to claim maintenance, you need to prove that I am in a legally valid, recognized civil marriage. And then secondly, I am not working, or I am working and I'm earning an extremely low salary. I am in financial need, and my spouse is in a position to afford to pay me disposal maintenance. If you are an older person, either until remarriage or death, or to pay rehabilitative maintenance. But there is no such thing as somebody wasted my time. Nobody wastes anybody's time. Either the marriage succeeds or it doesn't.
Oh, okay.
Okay, thank you so much. I just want to say the student who asked me to send the link, please be aware that I'm actually struggling. From my side, the chat, for some reason, I'm muted. It says I cannot send any message. So if there's any other student who's able to send the link, can you please, from your email, just copy and send the link on the chat, because I'm really struggling from my side. Okay, thank you. Zanele, let's hear what you have to say, Zanele. Zanele? Zanele? Okay, let's continue. Ntando?
It's in Tato. Thank you.
Okay, and Tato, can you just hold? I think Zanele has just heard me. Zanele, you can talk. Sorry about that, Tato. Zanele?
Okay, ma'am.
Okay.
Yes, ma'am. The question that I have is on page 99 on the prescribed book regarding the accrual claim and the accrual sharing. I don't understand it. And even the calculations, I don't understand. Must it be that a person who's getting the accrual have to get 250,000?
Okay, you're gonna have to send a private email on that, because remember today we are speaking about maintenance of a spouse after a divorce. So we can set up a private consultation or a private session whereby we will discuss a calculation of accrual and how accrual actually works.
Okay, ma'am. Thank you.
Thank you. Okay. Happy? Happy?
Thank you. I'd like to find out, us to have a conversation about the part where the court considers if there's any redistribution order in terms of section 73, 7.3, 7, subsection 3 of the Divorce Act. Yes.
Yeah. Okay. I'm not sure if you joined us last week, but there's been recent legal development with regard to redistribution of assets. Yeah? Before the Constitutional Court's judgment in April this year, spouses who were in a civil marriage for black spouses was before 1 November 1988, and then for white spouses was before November 1984. The court could order redistribution of assets from the other spouse. So the position has changed now in that spouses, black spouses who are married before 1988, their marriages are now in community of property. So if there is their spouse who at the time qualified, a black spouse who at the time qualified for redistribution of assets, now they are entitled to 50% of the joint estate, if they of the joint estate. So if they were to apply for spousal maintenance now, the court will now look at, are you in financial need, bearing into account that now you are entitled to 50% of the joint estate. The position but is different for white spouses, for white or for non-black spouses. Those who are still subjected to redistribution of assets. If the court has ordered redistribution of assets, the court will, before making an order for spousal maintenance, will have to look at whether those spouses are in need of spousal maintenance, bearing into account that some assets are going to be redistributed to their estate. Do you understand? So it is important to note that redistribution of assets and spousal maintenance, to look at it, will now only apply to non-black spouses. For black spouses, now the Constitutional Court has declared that that provision regarding redistribution of assets, it is unconstitutional, and their marriages are in community of property. So for black spouses, that no longer applies to them.
Thank you very much.
Okay, thank you. For now, we'll hear from Happy and Lesedi, and we'll just continue with other topic on the subject. Happy? Happy? Happy?
You've just answered my question, ma'am.
Oh, I've just said, okay, thank you. Ntato? Ntato?
Yes, ma'am, I would like to find out if I've been married to my wife for more than 10 years and I've been dependent on her. And after a court orders, after divorce, during divorce, a court orders that I shall get spousal maintenance from her.
Yes.
And by some good fortune, I let's say I win the lottery and now I have a huge sum of money. Can the court rescind the decision?
Yes, if your former spouse brings a court application, again, it will depend. If, let's say, the spousal maintenance was ordered in terms of Section 7, subsection 2, where there is no agreement, the court, there is a high likelihood that the court will order that the spousal maintenance be terminated because you are no longer in financial need. But if the spousal maintenance was ordered in terms of Section 7, subsection 1, which is ordered in terms of an agreement, the court will have to look at what the agreement says. So if the agreement says you are supposed to get spousal maintenance up until this certain period, the fact that you have won the lotto does not take away the contractual agreement that you and your former spouse have entered into and that which have been made a court order. So in the settlement agreement, when you're going to assist your client, you need to try and consider scenarios like, as you have said now, if the former spouse is in need of spousal maintenance and you put in this amount, you must also maybe include clauses which states that the maintenance will be terminated upon the former spouse gaining employment or no longer being in a position of financial need. Because if you don't put that, then the agreement, if it's silent on what happens if the other spouse is no longer in financial need, it is going to still be enforceable. Understand? So where you will get more protection is if the agreement was ordered by court, but where there is if the order was made by court, but where the spouses enter into a contract themselves, then you winning the lotto does not excuse your former spouse from still being liable in terms of your settlement agreement.
Okay, thanks.
Thank you. Okay. The two hands I'm seeing now is Lesedi and Rai. Rai, do you still have a question you want to ask?
I still do, ma'am.
Okay.
My question is, during the divorce, and then I got the maintenance for the spousal maintenance, and then the spousal maintenance was supposed to be paid maybe for a period of 12 months. And then after I got the order, down the line, the other spouse who's supposed to pay, he loses his job, maybe due to COVID or whatever. And then will I still be entitled to the balance of those other months left after he got his job again, or if he got a new job?
Okay, the former spouse, if they don't bring a court application for rescission or for the court to for rescission of that section for the maintenance order in the settlement agreement, yes, they will still be bound to make payment, even if, let's say, during that period they don't make payment and they eventually get a job. So if they lose their job, they need to bring a court application for rescission, and their defense will be they have lost their job and they no longer can afford the maintenance. And then the court there will decide whether will it temporarily suspend the payment of maintenance or it will terminate it indefinitely.
Okay, thank you, ma'am.
Okay, Lisedi?
Hi, ma'am. Can you hear me?
Yes, I can hear you.
I just wanted to ask about the rehabilitation maintenance.
Yes.
So after that period, let's say I'm receiving the rehabilitation maintenance, and then I don't get any employment, and I'm still in need. What's going to happen? And I actually have two questions, and then I also wanted to ask you that is spousal maintenance the same as alimony?
Okay, the first question is, if the agreement is, or the court order is, your former spouse is supposed to pay for a certain period. Once that period comes to an end, that is the end of it. If you have not obtained any maintenance, unfortunately, you're gonna have to see for yourself how you survive. Please always bear in mind that spousal maintenance comes to an end when the marriage terminates, and the court, but the court has discretion to order post-divorce maintenance. And if they have ordered it for this certain period of time, that is only going to apply until that certain period of time. No former spouse has a legal obligation to continue supporting their ex-spouse unless if the divorce order, the original divorce order, has stipulated that they must pay up until death or remarriage. Your second question is, we are talking about the same thing. Spousal maintenance is alimony, but we normally use the word alimony during the process of marriage. But once the parties have divorced, you can't call it alimony. Though the wording is, means the same thing. So it's post-divorce maintenance. It's just something that you get it as a privilege, because even in today's days, you are very fortunate if the court orders maintenance, and you are extremely fortunate if they order maintenance until death or remarriage, because the courts are reluctant these days to give an order for spousal maintenance because of the clean break principle, and also because of the notion or the principle that once a marriage has come to an end, the obligations also need to come to an end. Okay, Lesedi?
Oh, can I please ask? So
okay, who's speaking now?
Yeah,
who's speaking?
It's Lesedi.
Okay. Mhm.
Yeah. So let's say on the divorce papers, I ask for the alimony. Is that like because I'm in need I'm in need for financial support? Am I going to win?
Okay, you need to prove that you are in need, and you
Okay.
need to prove that the other spouse is in a financial position to afford. And also the court will look at these grounds. I will just list them just for the benefit of this session. And if, let's say, you were able to prove need, and you are able to prove that the other spouse is in a position to financially afford the maintenance, the other thing the court will look at is for what period will the maintenance be paid. That is where they'll have to decide, will it be a rehabilitative maintenance, or will it be a maintenance for a long time, for up until remarriage or death. And the court looks, there are grounds that the court will actually consider. These grounds are the spouse's existing and prospective means. If you are a 60-year-old woman, what are the chances that you will find employment? What education, what qualifications do you have? The court will look at the spouse's respective earning capabilities. Again, if your spouse is somebody who's very educated and their earning capabilities are extremely high, versus the spouse who was most of the marriage financially dependent on their spouse, The court will look at the spouse's financial needs and obligations. They will look at the spouse's age. They will look at the duration of the marriage. They will look at the spouse's standard of living during the marriage. And they will look at each spouse's conduct insofar as it may be relevant to the breakdown of the marriage. This ground is very important. It says each spouse conduct insofar as it may be relevant to the breakdown of the marriage. It takes us back to what the student was saying when I asked and when I gave an example that if I'm a housewife, I have a husband who travels a lot, and because of loneliness, I find myself a boyfriend. Does it mean that I should not be awarded spousal maintenance because of my conduct? The court will not just look at me and my affair, it will also look at the conduct of my husband. The question now is, did my husband's conduct of not being there in the marriage and always, leaving me alone, did it have any bearing with me ending up having an affair with somebody else? So the court will not just look at my conduct as a spouse who is looking for spousal maintenance, but they will also look at the conduct of the other spouse. And please believe me, students, the court does that because I know of a high court order where what I'm talking about actually happened where the spouses were married out of community of property without the accrual system. They had 2 children in the marriage. The wife was a very young lady. She was born, I think, 1979, 1980. They were married for 10 years, and she was a housewife. She was married to a chartered accountant whose job he traveled. The husband traveled all over, and most of the time, the husband was never there. Even when they went on vacations, the husband will just leave the wife and the children alone in the hotel rooms, and then he will just go wherever he goes. And then the wife had an affair. And because they were married out of community property without the accrual, everything belonged to the husband, and the only thing the wife could ask for was spousal maintenance. She brought a claim for spousal maintenance, and the husband opposed the maintenance. The wife was awarded 200,000 lump sum spousal maintenance, and the court or the judge held that or said that although the wife had an affair, the husband's conduct in the marriage also contributed to what the wife has done, and the wife could not just be punished and be left in a position whereby she just leaves the marriage empty-handed. Remember, for 10 years she was the housewife. She did not contribute financially, but she contributed non-financially, and she had nothing in her estate. So as a result, the court deemed that it is just that she be given a certain amount of money in terms of spousal maintenance that will assist her to kickstart her life. And as a result, she was awarded 200,000 lump sum amount. So this is relevant because the spouse's conduct has to be taken into account, but not just one, but to both spouses. And again, what the other students said, the redistribution in terms of section 7, subsection 3 of the Divorce Act. Here I have explained that now it is more relevant to spouses who are non-black, because black spouses say this provision has been declared unconstitutional for them. And the court also looks at any other factor which is relevant in the court's opinion to be taken into account. So it is important that you know this ground that the court look at, and for the purpose of your exams, also just look at when it comes to rescission what does the court said, especially the Supreme Court of Appeal judgment, and most importantly, when it comes to termination of the maintenance order, know the difference between how a maintenance order that has been granted in terms of Section 7, subsection 1 of the Divorce Act, how it is terminated versus the one which has been ordered in terms of Section 7, subsection 2 of the Divorce Act. Just know that because there is the difference regarding termination. As I have stated that when an agreement was entered into, you need to look at the terms of what the agreement says, and you may be bound by those terms, even if the circumstances change, versus the one granted in terms of Section 7, subsection 2, where if you bring in a variation application, the court can look at whether the circumstances have changed and if you are still in financial need. But that's it. Students, this brings us to the end of this discussion. If you have any questions, please feel free to send me an email. My email address is monarkn, is MONARKN @unisa.ac.za. And if you have sent an email and I have not responded to you, please just resend it again, because I get quite a lot of emails from students. And last thing, please, students, when you send an email, do not use your private email account. Don't use your work email account. Don't use your Gmail or your Yahoo email account. Please send an email, the email that you get from UNISA, your My Life email. The UNISA's policies is we must only respond to emails which have been sent through my UNISA emails. Thank you for joining today's session, and we shall meet each other again. Regarding the recordings of all these sessions, if you go to the PVL site on my UNISA, just go to additional resources. There is, we have uploaded them, but we have uploaded them as the links. Just press on the links and you will get access to the recordings. All recordings are there, including today's session. Today's session has also been recorded, and I think it will be available. I think they become available after 5 hours or maybe tomorrow. But I will also share the link tomorrow on the under additional resources. Student Zanele, you are the last one. Did you want to say something?
Yes, ma'am. I wanted to ask, can't you make to the like these lessons turn them into a podcast or something like that? Because they are easily accessible when you've made them into podcast, and then we can download them and then read them when we have like some spare time.
Okay, I'm just gonna have to see first what the UNISA policy says. Remember, as a staff member, I need to follow the policies of UNISA, so I need to first confirm if that is allowed. Then if that is allowed, so we can do it. If it's not allowed, unfortunately, we can't do it. Understand? Thank you for your
Okay, thank you.
Yeah, students, we shall meet again next week. Next week, where we'll be talking about the interest of children, of divorcing parents. Have a good day ahead and have a lovely week. We shall meet each other next week. Thank you so much. Goodbye.
Thank you, ma'am. Same to you. Have a good night and have a good weekend.
Bye.